Okay, thank you, thank you. Firstly, morning everybody, and thank you for having me over here today. It's lovely to meet all of you. David, thank you for inviting me.
Pleasure.
It's a pleasure to be here. So I thought, firstly, let me introduce myself, tell you a little bit about me, tell you a little bit about the firm that I'm with, and then we can talk about private mortgages, private lending. So I am a lawyer both in Canada and South Africa. I practice in Canada, though I was called to the bar in South Africa in '97. Practiced there for about a year in-house for an insurance company and doing professional liability insurance. And when I came to Canada, I worked, I articled and worked for a little while before I was called to the bar here at a downtown law firm, doing actually nothing to do with mortgages, personal injury work. And then in beginning of 2004, I started my own firm once I was called to the bar, which was end of 2003, and doing primarily corporate business work, a little bit of litigation in the beginning. Then as my practice progressed, was more corporate, commercial, and then real estate as well. I found that corporate clients required real estate as part of their as part of their transactions, and then real estate started getting really busy, and real estate became the primary focus, with corporate being there as well. Now, 2 years ago, I joined my practice with Cronus Rothstein Margles Capel LLP, which is a wonderful firm. We're known for short as KRMC. We're right at the heart of North York, Yonge and Sheppard. We're connected to the subway, so we're pretty much right there. I'm not sure if you guys know the Nestle building right there, so that's where we're located. I practice primarily real estate with KRMC. I do a little bit of corporate, helping the corporate group once in a while, and obviously my corporate experience helps me in real estate transactions as well, specifically when we do commercial real estate transactions, but I primarily focus on real estate. Now, KRMC is a full-service firm, with the exception of a couple areas of law. We're a full-service firm with departments in most areas of law. We have about, depending on changes from time to time, but we have approximately 35 to 40 lawyers. Would be considered a mid-sized firm with a staff of about, I would say, approximately 120 to 130. And that's where we're at. So I practice primarily, my group is consisted of generally about 4 law clerks, each specializing in different aspects of real estate, and I work closely with one of the senior partners who's also a real estate lawyer. And so that's KRMC. If you want to know anything else, of course, you can ask me at any time. I have a card here. Feel free to help yourself, and I have more if necessary. Okay, now I have a bottle of water. Just excuse me, everyone, if I cough from time to time. I had a cold about a week or two ago, so I'm still coughing a little bit, but that's fine. And I'll also be looking down. I made some notes. I didn't want to forget anything, so I'll be looking down from time to time. So if that's okay. Now, okay. So with respect to private lending, I want to keep it basic. I don't want to get too detailed, but what I'd like to give you guys a focus or a look into how we put together a private real estate transaction, a private lending transaction, and how we go about it, some of the challenges, where I see potential pitfalls, maybe how they can be avoided, and how we look at it from our end and what we go through in putting together a transaction. Now, the kind of private lending that we do, we act for large and small companies. We also do alternate lending as well. I don't want to get too much into that because that's not considered to be private lending.
Sorry,
Yeah.
Doug, when you say you do alternate lending,
Yes.
do you guys actually lend money, or you just do the legal work?
No. So what I mean by that is alternate lending companies. So let's say, for example, not to say we act for them, I would say let's say a B lender like Home Trust or Equitable would be, for example, we could call alternative lending. They wouldn't be
You
part
do
of
the
the.
legal work.
We do the legal
Okay,
work.
yeah.
Correct. So yes, that's a good
So
point
we can
there.
still arrange the mortgage.
That's correct. You got. I'll leave that out. I'll leave that to you. Exactly. So, but I'm not going to get into that too much because it's not private lending. and we also act for mixed mortgage investment corporations as well. Okay, now we do both commercial and residential mortgages. Okay, when it comes to private lending and real estate as a whole, we do commercial and real estate and residential real estate. Okay, the type of private mortgages we do refinances, purchases, construction mortgages, RRSP mortgages, where people would use the RSP funds to put together a mortgage, and then just the typical mortgages where borrowers are looking for additional financing. Okay, and now the RSP mortgages, that's a little bit more involved. That usually with trust companies. We can talk about that at another time, but that's part of private lending, can be as well. Right. Okay. Now, just to highlight, we typically act for lenders. Once in a while, we end up acting for borrowers, but that's not really our focus. We find once we start acting for borrowers, and it might be for a client that we've acted, one of our lending clients, we start getting into conflict of interest situations where we don't want to be involved with that because conflict of interest is not where we want to go. Now let's start with these. Now just to let you know, feel free to ask any. We'll have a question session at the end, but feel free to ask any questions at any time as well. I have no problem with that. Okay. Okay, now let's go over a typical mortgage transaction. Okay, now that slightly depends on the lender and the way they structure their mortgages. Each lender is a little different, and the instructions that we receive is a little bit different, and they have a slightly different transaction, the way they put together the transaction. Now, what generally happens, the first thing that happens is we would get instructions from either a broker or the lender directly. We'd get instructions, and with what would happen with that, we'd get all the relevant documents for the deal, the commitment, all the signed forms that they need to sign, and all the signed documents. We'd get that, okay, and then we'd for us the transaction would start. We'd confirm instructions with the client, and typically what happens at some points is we would get some type of a retainer from the broker, or maybe a representative from the borrower will drop off a retainer. That's usually a small retainer which would cover perhaps our fees and disbursements, or any other type of cost. We don't typically necessarily request that, but the lenders arrange for that. We don't get involved too much with that.
How much typically?
Yeah, it'll be small, sometimes 2,000-3,000, around 3,000, sometimes 5,000, sometimes 1,500, depending on the deal and what the lender feels comfortable with. So that's what, if it's a larger transaction, it'll be a little bit of a higher retainer. Okay. So once that comes to our office, sometimes the lender will tell us, don't start the deal until you get the retainer. So, okay. Once that comes through, we advise our client, and then we proceed. So now, okay. Now, generally, we'd get instructions via email. Sometimes they'll be by fax. In fact, one of our lending clients is at our building, so it's a little bit easier. Confirm receipt. The next thing we start to do immediately is we open up a file. We have a process of, we do the conflict of interest searches on the borrower and anyone involved in the deal, and then we do the searches. Okay. Now the searches that we do is typically we do the title searches, obviously, litigation searches, bankruptcy searches, PPSA searches, corporate searches, and we'd start with that. Okay. Once we do the searches, which don't take too long to get, the lawyer would review the searches. And if there are any issues that arise with the searches, we discuss it with the client. We'll tell them how do you want to handle it. We give them some advice. Is this something to worry about? Is it not? If it's not something that's necessary to be too concerned about, we move on. If it's something that we feel is we need to deal with it, we'd put it together in an instruction letter to the borrower's lawyer as to what we request to complete the deal. Okay?
So
Yes, absolutely.
searches are on the information about the borrower and the property itself?
Yes, and the property itself. Yes, that's right. Now, obviously, the lender and the broker, or depending on the particular lender, would do their own due diligence as to taxes and the fact that they actually want to do the deal. But sometimes they leave certain things that we look at. For example, let's say bankruptcy searches, right? So let's say there was a bankruptcy proceeding, or anything to do with the proposal to creditors. For example, 5 years ago, we let a client know. So did you know that generally they didn't know because they don't do those types of searches. They do more. They look into the immediate financial situation of the borrower, and then they decide to do the deal. And then we would tell them. For example, litigation. Right? For example, they might be involved in 3 or 4 litigation. For example, sometimes it could be a personal injury action. We're not too concerned about that. If it's something a little bit bigger, so we'll deal with it on a case by case basis. Right. So. Okay, so then, as I said, we'll do the searches, discuss it with our clients, and deal with them accordingly. Okay. The next step. Okay, so just to give you a little bit of a take of how it would be, the relevant clerk that's working on the file, usually we have a specialized private lending clerk who's excellent. In fact, we have 2 or 3 clerks that can do private lending, but there's one that typically focuses on that, would start to prepare the file. Okay, she would get the searches together, then prepare all the work, and the next step is to instruct the borrower's lawyer with an instruction, with a letter, and with all the documents that we are going to be required for the borrower to sign and get back to us so we can complete the transaction. We'd put together, so the clerk would prepare the file, give it to me. I would review the file very carefully, have a look at, make the necessary revisions, and then we'd instruct the lawyer. Okay, by the time I get the file, if there's any problem with searches, I already would know about it, and otherwise it's just preparing the file. For example, if there's easements on title or any types of subdivision agreements or anything like that, we ask for it to be removed from title. It doesn't always happen, but we at least ask. We deal with anything that we we require for the transaction. We put it in the instruction letter, and we also prepare all every single document that we want, and we require everything to be sent back to us signed. Okay?
A dumb question.
Sure.
What is an easement?
An easement is something that's on title that gives a right to someone. For example, let's say a right of way would be an easement, or
like hydro or something.
Correct.
Property.
Correct. For example, a developer would build a property that put a 30-year easement, and there'll be an easement on title whereby they can work on the property, cross through the property, work on pipes, on anything that they need to do.
And does that pose a risk to the lender in some way?
Not necessarily. So it depends on the easements and the right of way. Generally speaking, there's not too many easements that we're concerned about. So, good question. Different searches, different aspects of real estate. It depends on the deal. So, for example, some things that can come up in searches and easements and subdivision agreements and different things on title, for a lender, they won't necessarily care about that. But if someone was purchasing, they would care, because it can affect the value of the property, can affect various things, their use of the property, and it may not be something that they want to do or to buy. So, correct. So not always, but sometimes it can do, and we need to look at them very carefully. Okay. Now also, we if it's a condominium, we ask to be provided with a status certificate. We review the status certificate. Typically, there's not much in a status certificate we'd be too concerned about, because they're not purchasing. So, for example, we don't care about if they're allowed pets or they're not allowed pets or that type of a thing, or the condominium rules. But, for example, if they're in default of common expenses, we do care. We want those paid before closing, and also it gives a look to the lender as to the history of the borrower. Why is he in default of common expenses, right? Why is he not paying it? Why, sometimes, for example, it could be a corporation, the directors, officers are overseas, it's just an administrative thing. Sometimes it's a banking thing, but we do need to advise our client, and we do review status certificates as well. And generally speaking, our look is provide as much information to the lender so that they can make an informed decision. Okay. Then at that point we instruct the lawyer. Okay, now keep in mind it's an intense period because a lot of these deals are scheduled to close over a short period of time. Could be 3 or 4 days, could be 2 days. We need to move quickly, but we need to be very careful and always protect our client. So if it's specifically, for example, let me give you an example, if it's a purchase, right? They need the financing to do the purchase. It doesn't people don't often use private lending for purchases because it's expensive, especially for first mortgage, but sometimes can be a second mortgage as well. So we need to move because we don't want to be the cause of them not closing their purchase, because then they'll be in trouble with the seller, and then we don't want to put our client in any type of risk or any type of issue in that regard. And besides, our clients want to close. Right, so once we instruct, we start to wait, then the ball is in the borrower's lawyer's court, and the borrower has to come to the lawyer to sign documents. So we also ask for tax bills and water bills to make sure everything's paid, and if not, we require it to be proof of payment before closing, okay? And then we wait to get documents back. And then obviously once conditions are fulfilled, we close the transaction. At times, as I was saying, so it's an intense period. Now this is where sometimes things can get a little bit intense with private mortgages. For example, we'd get back documents and they're signed nilly-willy, like 50% of the document, well, maybe 50 is a little bit much, 20 or 30% of the documents are not signed correctly. They didn't sign, the guarantor didn't sign, or someone, or I don't know if it's intentional, sometimes it is, sometimes it's not, sometimes the lawyer was signing them up, maybe it wasn't experienced, maybe it was a junior, then we'd say, listen, we need this and this is not signed, you didn't provide the water bill, the tax certificates, this and that. And sometimes they would send us documents and then the conditions continue the documents continue to come. As all of a sudden we get the tax bill, the water bill, and the clerks are sometimes working on a lot of deals, and it's very intense, but we are very diligent. We want what we need to protect our client. So this is where it's intense because our clients want to close. Everybody's looking. We're getting emails from brokers. Is this deal ready to close? All of a sudden we get documents. Sorry, we've got 60% of the documents. We're waiting for this and that. The new lender's lawyer sometimes calling us. He's calling us because they want to, fund the deal. And you know what? Our interest is always our client, because at the end of the day, if we close, just to satisfy everybody, say, you know what, the deal's closed. If something happens later down the line, whether it's with an enforcement or a problem, a mortgage goes into default, we're going to hear about it, and that's when problems arise.
Are there always two lawyers in a private transaction?
Good question, and I was going to get to that. Yes, typically yes. We try everything possible not to act for the borrower and lender. The Law Society has very strict rules about conflict of interest and acting for the borrower and lender. There are very, very strict rules. It has to be a finance company. There are various rules that has to be under 50,000. And good question, but yes, in our private lending transactions, once in a while in alternate lending, when we say what I was saying before, let's say, for example, a home trust, we don't act for a home trust, so I'm just mentioning them, they would want us to act for the lender and borrower, then we go into what is a finance company. That's something that we go on a case by case, but private lending, yes. I know it's more expensive for the borrower, but that's the way it is, and it's best for the lender at the end of the day. And I'll get into that. And I'll touch on that a little bit later as well. Now, just to let you know, we're not allowed, or we shouldn't have direct communication with the borrower. Okay, we deal with the borrower's lawyer at all times. If the borrower calls us, we tell them you need to get your lawyer to call us. They're not our client. It's a conflict of interest, and they have a lawyer, and we deal with the lawyers. Okay, we don't deal with borrowers. Now, once in a while, borrowers call us. When we're closing, this and that. We don't. We do our very best. The way that we look at it at the end of the day, our focus is always, if this mortgage goes into default, we don't want to give the borrower any reason whatsoever to bring up a defense. And the fact that we, eventually, once they get comfortable with the lender's lawyer, they start calling you, it starts to conflict of interest starts to arise. Okay. So this is the private lending transaction. I'd like to get on to discharges. And are there any questions about private lending, or otherwise maybe we can ask some questions at the end, unless there's questions at this point?
How important, just say you were to loan somebody under 50,000.
Mm-hmm.
How important is the independent legal advice? Just say I'm the lender and I
Yes.
loan someone 50,000,
Mm-hmm.
or I loan them 30,000,
Right.
and you're,
Our outlook is that independent legal advice is always important. In fact, we don't only ask for independent legal advice, we ask for independent, we actually put in our documents ILR, independent legal representation. So not only are they giving legal advice, they're actually acting for the borrower. We want to pin them down on that. We put it there, certificate of independent legal representation. Now, you can probably get a deal done without it, but we don't advise it because it's important for the borrower to understand what they're signing, because it's, these documents are legal documents. Some of these borrowers have never entered into a private mortgage transaction before, and we prefer to get it to, it's important. We always believe ILA is important. But you can get a deal done without it, but we don't advise it. We don't typically do a lot of deals under 50,000. It may arise from time to time. We would, if pressed, do it, but we would get a waiver from our client. We prefer to get ILA. I know, but I know it's a small deal. Everybody wants to cut costs because it's a small transaction, and the borrower,
No,
at the end of the day, doesn't make it
would that
viable.
cause the deal to just go and be dismissed?
Not necessarily. No, we would deal with the lender, and we would explain to them the situations, what the problems that can arise, and if they still want to do the deal, we would do the deal. Right? You can under 50,000 under the right circumstances. Not necessarily. I understand everybody's trying to cut costs, because at the end of the day, sometimes it's just not worth it for them to pay our fees, because keep in mind, the borrower pays everybody's fees. They pay our fees, they've got to pay their lawyer's fees, they've got to pay a broker fee, a lender's fee, etc., etc. So, we understand that. Typically, we don't, I can't remember the last time we did under 50, but the Law Society, under the right circumstances, does allow it.
Okay, but the borrower can waive independently.
The borrower can waive, yes, and we would get a separate waiver from our client as well, the lender, but yes, the borrower can waive under the right circumstances, under 50.
But if the lender says, I want this borrower to have ILR,
Yes.
period.
Yes.
Then the only way the loan's gonna go through.
Correct.
Is if the borrower gets the
Correct,
ILR.
and we would be happy with that. We would advise our client for that to happen. That is correct, yes. Now, let's talk about discharges. Discharges, they seem simple. You get a request for, sometimes it's a day or two. You get a request for a discharge statement, and then you get it. We send that to our client. We get that from the borrower's lawyer. They prepare a discharge statement. We send it to the borrower's lawyer, and they pay it out. But it's really not as simple as all of that. It's not that simple, and that's where problems start to happen. Why? Let's get to that. The borrower, sometimes it can happen where they look in. Sometimes let's look at a typical discharge scenario. Let's look at a refinance. Okay, they're looking to do a refinance for whatever reason. They need more money, maybe a better deal, whatever the case is. We get a letter from the. Sometimes we don't like that. We get a letter from the new lender's lawyer, which I don't like, because they shouldn't be. We don't really have any business with them. We should be dealing with the borrower's lawyer. But sometimes that happens, and we get to the bottom of that. And once in a while we do deal with new lender lawyers. We get that. Now we send that to our client, and sometimes we say we're looking to close in 2 days. We need that. We send it to our client. Our client hopefully prepares the discharge statement very quickly. We send it to the borrower's lawyer. This is where some of it, and I'm going to get to that, some of the pitfalls, and I'll touch on that a little bit now with private lending. All of a sudden, they see these costs that they didn't know about. I didn't know that if I asked for this within 6 months, then there's this penalty, or not penalty, or this 3-month payment. Or I didn't know, for example, a typical thing would be our client advising them, listen, your mortgage is coming up for maturity. Are you going to pay it out, or are you going to perhaps renew? We do a lot of renewals, and we don't hear from them. All of a sudden, one day before maturity, we get a discharge statement request. Now it's almost impossible to close the deal because we need to still get it to our lender. They need to prepare the discharge statement, and sometimes there's a new lender's lawyer. He wants a DRA signed. Everybody know what a DRA is? Document Registration Agreement. I'll get to that. They want certain things signed because keep in mind we have a mortgage on title. The new lender now is giving the client money, and we're getting money to discharge our mortgage, and the new lender's lawyer via the borrower's lawyer wants security that his mortgage, that we're not going to release funds up until the point where our mortgage is discharged, and it's private lending, right? So typically what we do with given undertaking, we undertake to not to hold funds until the mortgage is discharged, etc. The problem is the law's changed a little bit. Law Society does not want undertakings being provided in private mortgages. They discourage it, and I don't agree with it, but which means we have to now get into a DRA, which is in real estate, the Document Registration Agreement. That's where there's an agreement between the three lawyers, the new lender's lawyer, or sometimes the purchaser's lawyer or the vendor's lawyer, and us, whereby everybody is undertaking to comply with certain obligations in the deal at a certain point, at a certain time, and to hold funds, etc., etc. So we don't have a problem. We know we're going to do the right thing. We're not concerned with that. The problem that happens is by signing a document registration agreement, we now become part of their transaction. So if something happens between the purchaser and seller, and their deal doesn't close for some reason due to, many reasons why deals don't close, and if they get into some type of litigation or issues, we get brought into it. Now we're part of this document registration agreement, and if it ends up going to court, or if there's a complaint to the Law Society, we're all of a sudden part of this transaction. We really don't have any business with the new lender's lawyer, or any of the other lawyers on this agreement. But sadly, we now have to start entering these agreements. We took a strong position not to enter these agreements. We have to now, and another thing is it's more work, in a short amount of time, because I have to now review this document registration agreement and change it to make sure that our lender, our client, is not unnecessarily exposed, and that we're not necessarily exposed as lawyers. So we have to amend it accordingly, send it, and we get that done. So discharges are not as simple as because now we have other lawyers involved, and everybody wants to protect themselves without giving too much to the other side. So now going back to all the costs, that's one of the pitfalls, and as I was saying to David, we'll discuss some of the pitfalls with private lending. When there's a discharge that comes to the fore, all of a sudden the borrower didn't understand the deal really. He didn't know that that these costs were going to be charged. He didn't know that if he asked for it a week after maturity, he thought, what's the rush? You're gonna pay a penalty, or you're gonna pay some type of an extra month or an extra 2 months, and sometimes those couple extra months could be $6,000, $7,000, $5,000, depending on how big the deal is, right? So and that's where issues begin, because we start getting calls from the borrower's lawyer trying to argue their client's case, why they shouldn't be charged these costs, and then and that's also where the lender, we would discuss with the lender what if they want to reduce some of their costs, what they want to do to close the deal, to do this discharge. And sometimes the lenders are very frustrated with the borrowers. They've tried to communicate with them before it even got to us. The borrower was not interested, and all of a sudden everything's a rush, and they don't want to pay this, and they warned them. And I'll go back. So one of the pitfalls, somewhere along the line in putting together this transaction, someone didn't advise the borrowers properly about all the consequences of the transaction, all the costs that are involved in the transaction. A lot of times some borrowers are sophisticated, some are not. Some don't understand. It's all everything's nice and rosy when you're getting funds. Oh, sign these documents, do this, do that. You'll get your funds, and you get your funds. You comply with conditions. But when there's discharges and refinances, everything comes to the fore. And then all of a sudden, that's when the lenders could get into legal actions where the borrower starts to say, you know what, I'm going to sue the client because I don't believe I should be charged these costs. And then, thankfully it hasn't been, there've been threats, but it hasn't happened on our case. Now we have some aggressive lenders that really won't give an inch. And then they got to deal with the outcome of that. So that could be on two situations. Either the person putting together the deal didn't advise the borrower properly, or the borrower's lawyer, did not advise them properly about the transaction. They didn't go through the commitment properly. They didn't explain to them. It's all very well understanding, you have personal liability, etc. But what happens when, the mortgage matures? People don't understand. 12 months comes by very quickly. Comes by very, very quickly before you know it. And sometimes they don't know what to do. Exactly. They quite frankly don't know what to do. And it's a problem. It is a problem. And it falls on our lap.
Are your discharges not normally rolled over like people are used to? Is that
what do you mean by rolled over?
Extended for another term on the same
Okay,
conditions.
good question. So if then that wouldn't be a discharge. It would be a renewal. So then my next actually thing that I'm going to talk about is renewals. So it wouldn't be a discharge. It would be a renewal whereby the borrower would be staying with a lender and renewing for another term.
Do you mean discharge on the appointed
Mortgage.
term date or on another date other than the term date?
Both. Both. So anything where our client will be discharging the mortgage and they would be getting paid out for their mortgage, including interest and.
But there would be a schedule of these extra fees you can count
Yes,
on, just they weren't.
correct. And our clients have everything and everything's there, but the borrowers sometimes were not informed properly, and when they all of a sudden see them,
Surprise.
also, whoa, I didn't know this and I didn't know that. And I will admit that some lenders push the envelope, trying to get fees here and there, and we tell them, you know what, you shouldn't be charging this. And it's a battle because some private lenders, don't tell me how to run my business. This is this. I do my. This is how we've always done it, etc. And then we advise them. We have a strong mortgage enforcement team at KRMC, which I work with closely with when our mortgages do get to enforcement. Doesn't happen often, but they do happen from time to time, and it's a good service that we can provide to our clients when the mortgages are in default and we need to start enforcement proceedings. We have a department at our team that can do that from right up until the end, and I'll get to that. Okay, I just want to see, so with respect to discharge, I want to see that I've touched on every point. Right. So once again, discharges, once everything's in place, we'll do the discharges. Now let's talk about renewals. Another thing. Renewals are when the mortgage comes into maturity. We send the borrower. We don't get involved with that too much, even though we know the mortgage is coming up to maturity. The lender deals with that, okay, and they send them, because we can't have direct communication with the borrower. And what we do though, on our client's instructions, is send a letter to the borrower's lawyer saying, listen, your client's mortgage is coming up for maturity. Are they going to be renewing? Please let us know. That we'll ask our client if they're interested in renewal, or are they going to be paid out? Please let us know. And all of a sudden, silence. Right? Sometimes it's because the lawyer is not acting for the borrower anymore. Okay, sometimes they didn't know them. It was just a single transaction, or sometimes the borrower is not getting instructions from his client, or sometimes the borrower's got a new lawyer. So either way. So for renewals, let's say everything comes into play and they agree to a renewal. Okay, they've agreed. It's a little bit late. They've gone over the maturity date, but they've settled their differences. They're going to do a renewal. What we would do then, we would do searches again. Okay, we would. They may not be as detailed. For example, we probably don't need a bankruptcy search. We probably don't need a litigation search. We do need a parcel search to make sure there's no more other mortgages on title, even though it doesn't affect us. We want to know. We would look at the status certificate again, if it's a condominium corporation, just to see that everything's in order. Now, status certificate, our clients may waive sometimes if they want to do a quick renewal, because status certificates can take 10 days to get, and it's a problem. We ask for tax and water bills again. We want to make sure taxes are paid and water bills, because our clients need to decide, do we want to continue the relationship with this borrower or not?
Property
Because
taxes?
property tax, property tax. Property tax.
Income taxes.
No. Income taxes, we don't get involved with renewals. Income taxes are generally a part of the due diligence process that the lender would partake in before even agreeing to do a deal. Now, if there were problems and this mortgage went into default and it was remedied, if they want us to ask for that, we will. We can ask for that, but it's not typical part of the transaction.
Is there a fee involved in this?
Absolutely, yes, yes. So this is another part of where sometimes borrowers are not informed.
Right.
Lenders take a renewal fee, a lender fee, because the lender look at it this way: the lender can take this money, pay me out, I'll invest in a new mortgage, get my 2%, right? Or I'm going to do a
2%
renewal,
fee.
2% fee, lender's fee or renewal fee, correct,
Yeah.
or do a renewal fee. So a renewal fee would be at 2%. Once again, that's private mortgages are very lucrative. So for example, sometimes I'd agree on a 1%, 1.5%, or whatever. That's out of our hands. That's between the lender and the borrower. And so yes, and we would charge a fee as well. So the typical fee to do the deal. So let me explain to you how we do that. We prepare an amending agreement whereby we get a renewal offer from our clients that's signed by the borrower. They would send it to the borrower. The borrower would sign based on the new terms. Sometimes the interest rate is the same, sometimes it's lower, sometimes it's higher, sometimes the principal is increased. Right, and whatever other terms that are part of the renewal offer that we get, we prepare an amending agreement that the borrower is going to be required to sign, okay, with an acknowledgement and direction, basically the borrower authorizing the registration of this agreement together with a notice. So the notice would be what would be registered, and the amending agreement would be an attachment to the registration, okay? And the amending agreement would basically say, there's an assignment of rents, there is a mortgage, and all the terms. It's a 2-3 page agreement, but it says a lot. Where basically all the terms, they basically agreeing that all the terms and conditions of the original mortgage apply, and besides the new terms that are specified herein, and we do that. So we have an amending agreement, a notice that we prepare, and. And that's that. Now we also require them to sign. We also update the PPSAs as well. So keep in mind, as part of mortgages generally, with the lenders we deal with, not all, but generally speaking, we register PPSAs as well.
What's
We get
a
them.
PPSA?
A PPSA, personal property security agreement. So basically, when we do a mortgage, we get them to sign a document stating that we register a PPSA. Basically, in the personal. So as you know, registrations of mortgages are in the Land Titles Act under the land registries. So this is in the personal registry. So if someone does a search, they can see that this particular person has a mortgage. And an assignment of rents or whatever else they've signed, a GSA, for example. In transactions we get GSA signed, general security agreements and guarantee agreements. Okay, we basically say in the PPSA that this secures all of these as well. Okay, so. So we get them. So we register PPSA. We get them to sign a form that they agree for the PPSA to continue, and we get that done. Okay. One condition is that once we get all the documents back signed for the renewal, we would then register the renewal. Okay. And then once again, it continues for another year or another 6 months, whatever the terms are. Okay. So that's renewals, okay? Let's talk a couple of pitfalls. As I was saying, one of them is communication. I believe if there was better communication in the beginning, okay, where the borrower really understood the deal and not only, their private liability or personal liability, but also on maturity. okay, that could resolve a lot of the problems, okay. Yeah, so to me, it's all about communication and really pinning down the borrower. Now, that's where it's so important, as you can see, for the borrower and lender not to use the same lawyer. Because there you can see on discharge. So can you imagine, just to go back to your point, can you imagine you're sending a discharge statement and all of a sudden these charges or whatever the case is the borrower is disputing, and the lawyer is caught in the middle, and because he's active for both parties. So now they have to get a new lawyer, the lawyer has to step out of the deal, and it's a problem, okay? So that's why as investors, get two different lawyers, okay?
Like if there's a conflict, then you can't work for either.
Exactly. If it cannot be resolved, we would try to
Two new lawyers, yeah.
Exactly,
Yeah.
exactly, and then the cost would be even increased.
But,
You know? Mhm.
on an institutional deal,
Yes,
there's usually one lawyer.
yes,
Is
yes.
that lawyer representing both parties?
Yes. So, for example, institution deal like a bank, for example.
Yeah.
Yes. Yes. Then yes, that's right. But we do get an acknowledgement, basically where the borrower is acknowledging that we're acting for the bank and for them, and that they understand that if there is a dispute, we would have to remove ourselves. Yes, but the law is stricter with financial institutions. The laws. Whereby the law feels more comfortable for it to be the same lawyer, you know, because they have other restrictions and obligations to comply with that private lending companies are not obligated to comply with. So
Right.
correct. Now where you gets a little bit iffy is in private mixed mortgage investment corporations. Can you use the same lawyer? It's a gray area. You know, some of our clients want us to. You know, we'll touch on that another time. That's another talk altogether.
Interesting story.
Yes.
I've loaned somebody 30,000 10 years ago.
Mm-hmm.
They didn't pay it.
Mm-hmm. You registered a mortgage?
Registered the mortgage.
Mm-hmm.
The lawyer that registered represented us both,
Okay.
okay? That lawyer, okay, nice person, has got to an age where he can't remember too much,
Mm-hmm.
and the paperwork has gone like it's got destroyed,
Mm-hmm.
okay? How valid going to court to collect that mortgage?
Good question. So just keep in mind, I'm not a litigation lawyer and I'm
Yeah,
not
no,
an
yeah,
enforcement lawyer, but
That's
I
a
think
guess.
it would be pretty valid. If you have a mortgage, it's better to have all the supporting documentation like the acknowledgement and direction and everything that was signed. So it's valid, but the borrower would probably be able to raise some defenses that you would have to contend with. It's not as straightforward as, you know, as if you had all the file completed and all the documents signed.
So when it
So it
does-
doesn't, but you still
Yeah.
have a mortgage. You have a mortgage.
So when it goes to court,
Mhm.
okay, and the lawyer is, the borrower's lawyer is in court for 1, 2, 3, 4, 5 days.
Mhm.
Eventually a judge would be saying, okay, we've got some papers that aren't here,
Mhm.
but we'll just use some logic.
Yes, they would have to look at the case as a whole,
Yeah.
see if there was a legitimate transaction here, if the borrower wasn't duped in any way, if everything was in order, and he'd have to make a ruling based on the information and the facts that he has. Now keep in mind, there's no black and white. Every transaction is different, every deal is different, and every case is different. That's why there's litigation all the time. So yes, you have a mortgage, but you know, depending on the transaction. It sounds like your transaction was a clean transaction, but, you know.
Because some time passed, you said like 10 years, right? Is
Yes.
that what you said?
Yeah, 10
Yes.
years.
Has that got a bearing on it?
No, because it still is, there's a
No,
mortgage on
but you haven't
top.
done anything for 10 years. Now you go to court, is the court gonna say,
No, all right.
where were you 10 years
So
ago?
this was, well, we've been there a few
No,
times.
no, but you still have a security on title. So we enforce mortgages that are 35, 40 years of being on title, for example, for big banks. There's, for example, mortgages that have been on title for 50, 60 years because of certain issues with the land that may make the mortgage invalid. and we try to correct it to make the conditions so that the mortgage is valid. That's mortgage
I
enforcement.
just wanna make a
Sure.
comment here. It's apt to, so
Sure.
let's try
Let's
and
wrap
start
it up.
winding down.
Sure.
And if people wanna stay behind, unless you
Sure.
have to run, they can talk to you, and of course your business cards are on the table.
Absolutely.
So
Sure, let's try and wind it down. Okay, so the last a few things that what I'll do is the other things that we have to be careful of is guarantors. Okay, very, very important. And I was going to speak about guarantors a little bit in more depth, but we can maybe chat about that another time. Guarantors, you must request for guarantor to get ILR. Very, very, very important. Even sometimes if it's a husband and wife. We'll talk about that another time.
And from a separate lawyer than the borrower.
Correct,
'Cause they have a
and
different
that's
interest.
right. And the lawyer, and they don't like that because it's increased costs. And then we start getting, the borrower calls us, oh, I've known these guys for 40 years, will you waive? We ask our client, will you waive this? If the client decides, they feel comfortable, maybe they've already got a mortgage with them prior to that sometime. But generally speaking, just in a general transaction, they must get ILR, okay? Sometimes we're faced with guarantors being overseas, which is another situation. So these various aspects to private mortgages. Now, that's guarantors, power of attorney, okay? A whole topic, okay? For example, sometimes we'd get a power of attorney, the power of attorney is somewhere in Asia, and the donee is here. We do request for the power of attorney as though he was the borrower to sign all the documents and to get ILR. But what we would also ideally like is for the actual person providing the power of attorney, the donor, to basically confirm that they know about the deal and they're authorizing it. The last thing we want is someone saying, when we have to enforce, someone saying, hey, I didn't, this guy defrauded me, I didn't tell him to do this deal, even though the power of attorney says that they can do it. Okay. Next thing is enforce.
Specifically authorize that transaction.
Yes. It's not always possible. Keep in mind, it's difficult to get, especially in short transactions. Ideally, we'd like to get it. The last thing is enforcement. We have an enforcement team, and this all comes together in enforcement. If we do everything correctly, we put the deal, we fight the borrower's lawyers in the sense that we try get everything in order to protect our client, enforcement will be clean. And even though they may bring an action to defend it, we'll win. We're very successful with enforcement. Our enforcement group will manage the property for a couple months. Generally speaking, if it's not ready for selling it, I'm not even going to get into enforcement. We can talk about it another time. I can provide some information if anyone wants to stay and speak about that. And generally speaking, otherwise, private mortgages, you need to be, just so you know, be well informed, make sure the borrower gets a lawyer, and they're not as easy as it seems, but they can be very lucrative, right? So I'll leave it up to there. We can always chat another time. At this point, just thank you all for coming by and listening. It's a pleasure to meet all of you. Thanks, David, for inviting me. It's a pleasure.
Much appreciated. Yeah.
And sorry about my South African accent.